Join one of Virginia's oldest and most experienced personal injury law firms as we explore how the law does and doesn't work, the art of leadership, and the power of community. Now, here are your hosts, Peter Burnett and Jonathan Slater.
Well, good morning. Today we've got Buta Biberaj with us. Buta has been a friend and colleague of mine for every bit of 25 years here in Loudoun County, and our practices have been a little bit different. Her focus has been primarily criminal defense, while my focus has been primarily personal injury work. But we've crossed paths from time to time and certainly have known each other for lots of different events that take place in the bar and events that happen in the community and matters at the courthouse that are of import to everybody. And I can certainly say without qualification that the community of lawyers in Leesburg regard Buta as one of the better, if not best, lawyers that we've been blessed to have here in the county. And the fact that she's running for Commonwealth Attorney is something that I think is complimentary to the community in terms of being assured that we would get an exceedingly bright, conscientious, experienced attorney in that position were the voting public inclined to elect her. And with Buta here, I'd just ask you to tell us a little bit about, one, your legal background and experiential background as well, and then we'll talk a little bit about what your thoughts are for the Commonwealth Attorney's Office.
Excellent. Thank you, Peter. I opened my practice in Leesburg in 1993. And I had come out here with a colleague of mine who had also graduated from law school. We both graduated from George Mason. And our thought process back then is that we would be these little country lawyers for about a year, learn how to be a lawyer, and then go to Fairfax where real lawyers practice. The community engaged us so well, and it was really such a nice opportunity for us to become an integral part of Loudoun County's legal system that I've never left. My office has never been more than one block away from the courthouse. So this is where my roots have been since 1993. And then I moved into the county in 1996 because I identified that Loudoun County really was the best community for me to be able to have an impact and help the people that, trust us to be able to represent their interests. As you indicated, my primary focus has always been criminal defense because I was and still am a staunch believer in the Constitution. I want the system to be fair. I want people who come before the courts to understand that their day in court is one that's going to be done in a fair manner. And seeing that sometimes not be the case has always made me that much more interested in making sure that my perspective and my efforts are towards upholding the Constitution and making sure that my clients' interests are protected. Other areas of law that I've dealt with is being a guardian ad litem, which, Peter, as you know, that is a position that the judges pick you as the attorney to represent the interests of the elderly or juveniles who otherwise may not be able to have the voice that they need to protect their interests. So that's a position of trust that I've had 23 years of honor to be able to serve the courts. I've also been a substitute judge for almost 12 years. That is also something that the circuit court judges honor you with appointing you to, but it's always based on the position and the endorsement of the General District Court and the Juvenile and Domestic Relation Court judges, because that's where you would be sitting as a substitute judge. Full powers of a judge, but you're just not hired 100% by the Virginia Supreme Court or paid in that fashion, but you still serve the purpose of being a judge presiding over trials and pleas in those courts.
And in Juvenile and Domestic Relations and General District Court?
Yes.
Where you would sit as a sub?
Yes.
Okay.
And it would be statewide.
Statewide?
Yes. So I've been down as far as Page County. I've been in Winchester. I've been down in Fauquier County, Fairfax, Prince William.
Have you made it down to Orange County?
I wanted to say yes, but I don't recall whether or not I did. So now I can't remember if that was as a litigant or as a substitute judge, but I've been down to Orange County twice.
And another little piece of interest here is that you've been doing some prosecuting in Herndon.
I have. I've done that within the last year, and that was as an opportunity to be able to actually shore up my resume to say that, yes, I have some criminal prosecution experience. I have civil prosecution experience. I've been doing that for 25 years. And basically being a prosecutor is the person who takes the lead to initiate a case, make sure that they have the witnesses and the evidence to be able to present their case to a trier of fact, a judge or a jury, and then being able to go ahead and take it to its completion, which would be to a sentence. So I've been prosecuting cases for 25 years, but predominantly has been civil, and then within this last year also doing criminal in the general district court.
Well, that's a phenomena, if you want to call it that you and I share. We have the burden of proof, and some say, some fairly fancy, highly respected lawyers say that this parsing of the burden of proof is a little bit phony, that people either believe you or they don't, and that is what our system is based on. So when you have the burden of proof, or when I have the burden of proof, I'm not sure that it's that different than a prosecutor trying to prove somebody was driving inebriated or committed larceny or whatever else it is. You've got to convince the trier of fact that your position is the accurate and truthful one.
Yep.
Whether you're in the civil or the criminal arena, it's all about building the case.
Yes.
On the other side of the V, it's about trying to pick that case apart and find the holes in it.
To undermine the case.
To undermine the case.
And think about it from the defense perspective, be it as a defense attorney in civil or criminal law, what you're doing is you have to anticipate what the prosecution is going to do. That's why you have to study it, first off, from the perspective of a prosecutor. If I am the prosecutor, how am I prosecuting this case? What is the charge? What are the elements? Who are my witnesses? What is my evidence that I have to bring into court for it? And then from the defense perspective is, as you said, how do I show that there are some weak links or just some obvious missing pieces in that presentation? And then the judge perspective is, what would I decide? What are the burdens of proof, as you indicated? What is the evidentiary requirements? Because you have to know the law of evidence to be able to do that, so that you have that trifecta going on, so that you could be the best prepared in how to present that case or defend against that case.
And so Buta comes at this, at the Commonwealth Attorney's position, with experience from all three angles,
Yes.
from the bench, from the defense, and from the prosecution side.
And that's really one of the reasons why I decided to run for office, is because I have that perspective that is complete from all perspectives. And having that, I think, lends the right approach to how to weigh a case, what is good for the community, because at the end of the day, as a prosecutor, really your job is not to convict, it's to do justice. And justice is a very compelling reason. It's a high, it can be an overwhelming sense of responsibility, because you're trying to do the right thing by the victim. You're trying to do the right thing by the witnesses, by the officers, by the accused, by the system, by the community. That's a lot of moving parts. And you're tasked with doing that. So sometimes, you could sit there and say, oh my gosh, what do I do and how do I get the right answer? And the right answer has to be the justice part, doing it with integrity, honesty, and always upholding the Constitution to say this. There is no case that's worth undermining our system. There's no case that's worth undermining the Constitution, because if we abandon that now, that's when we get bad prosecutions. That's when we get the wrongfully that are convicted. That's when we get the accused who is rightfully convicted that gets off without being consequentially punished. That's when bad things happen, is we don't uphold the Constitution.
I think it comes as a surprise to many citizens and non-lawyers, and maybe even a few lawyers, that the prosecutor has an additional burden that is not shared by defense counsel to be certain that the entire proceeding is infused with fairness, if you will. That the prosecutor can't focus exclusively on winning by almost any trick or inappropriate method that he doesn't or she doesn't get caught doing. That their duty, caught or not, is to assure that the process that ends up in either an acquittal or a conviction is fair from beginning to end. And as you say, that really goes a long way towards supporting a confidence of the community in the system as a whole, which is essential for a constitutional government like we have in the United States. I think that there is little doubt about your legal skill set, if you will, but having, as John says, come from all these angles at essentially the same system in the same courtroom. I think what might be of great interest to our listeners is, and to me, is what you see as being in need of change in the Commonwealth Attorney's Office in Loudoun County, Virginia in 2020 and forward. What you see as its strengths, what you see as things that aren't going as you would have them go. Give us your thoughts about that.
As a resident of Loudoun County, as well as the intendant prosecutor, my job is, and my hope is always, that Loudoun County remains as safe as it is and safer. And what we have to do is we have to look at that from the perspective of when we have victims who are coming before the court. While the case is pending, their needs are somewhat addressed. They may be referred to services. They may have the attention, the hand-holding. Once the case is done, then there is no further contact with the victim. And as we know from a trauma perspective, that may be the time when the victim is actually ready for healing. We don't have a synergy in our system. So this is not something that the prosecutor's office can do by themselves. But with the power and the connection of the prosecutor's office is they have the ability to connect with other services and connect with, families and encourage them to be part of that solution for that victim so that they can start healing and they could realize that, this whole process, as stressful as it is and as disheartening as it may be, was worth it because now the community has come and is in support of them.
Well, help me with this.
Sure.
When I started practicing, and maybe when you started practicing, there wasn't a victim witness program in Loudoun County. The prosecutor would undertake the prosecution, might meet the victim for the first time on the day of trial, and might meet the arresting officer for the first time about that case on the day of trial, and off they go. And when the result has been achieved, whatever it is, everybody goes their own way.
Right.
And I think it probably started in the juvenile court that people started to think about what is the impact of this process on these young people, both the victim and the juvenile offender, who folks wanted to help move in a better direction than being in court. And let's use our system and the various resources that we have to try and get some healing for the victim and some change of pathway, if you will, for a young offender. And so I don't think a lot of people are necessarily aware of how these different resources today are integrated into the Commonwealth Attorney's function, if you will. They're not part of your office, but they are integrated into that function. And do you see that as something that should be expanded, continued, made smaller, made larger? How do you see it? So
let's talk first about your victim witness office. That is actually a subset of the Commonwealth Attorney's office now.
Okay.
So it's within their office, and they have attorneys who work hand in hand with that department. We still have the issue where attorneys are not meeting with the victims in advance. We go to court.
I'm sorry to interrupt. That's just so important, though, because I've worked in a prosecutor's office before, and we had a very good victim witness program. But what you cannot do is you can't just hand the victim off to victim witness and not talk to them again until the day of trial. It's just not the way it works. It's not the way that it should work.
Right.
The attorney needs to maintain contact, develop a relationship with that victim so that when trial does come, they're comfortable. They know what to expect. They know the prosecutor. They're ready.
Think about the amount of time we spend in cases where we are plaintiff's attorney. It's the rapport. It's also what I tell a lot of times my clients is, you have to learn what my language is. I have to learn what your language is. It's not that we're speaking literally a different language. It's all in English. But how I use certain terminology is different how you perceive it and you understand it. So the courtroom can't be the first time I use a phrase and you sit there and you've got deer in headlights look and go, uh-oh, what are they asking me? That's where the time commitment is. We've had the, in my opinion, the misfortune of going to court where the prosecutor says, I don't want to talk to the victim, especially in domestic relations cases, and that's for domestic assault and battery, because I don't want Brady to be created. And Brady, for listeners, is, well, I don't want the witness to tell me something that undermines my case. And my frustration comes into place is this. have you lost your god daggone mind? Because you want to know that information, because either it's going to be truthful about what's happening in that person's life. That doesn't hurt you. Or it's going to give you more insight as to maybe the dynamics. That doesn't hurt you. Or you have a problem with the case. That doesn't hurt you. So how does more information become a problem when you're dealing with the community and you're trying to preserve the community's safety?
Let me expand on Brady just to make sure that anybody listening to this understands what Brady requires. Brady requires that a prosecutor disclose to the defendant any exculpatory information that they learn. And so if in interviewing that victim, the victim says something that could be helpful to the other side, it's not just that the prosecutor knows about it, and now the prosecutor has the additional burden of telling the defense about it. And I think a lot of them, as you say, are shy about learning it because they think it's more important not to disclose it to the other side than for them to know it themselves. Is that what you're saying?
Yeah. And for me, that's a office policy limitation. Because the office policy should be, I am not prosecuting a case if I've never spoken to the victim. Because again, if we're looking at justice, what is the purpose? It's not just to protect the accused, but I have to protect the witness as well, the victim. I don't know what you're going to tell me, and maybe I don't have the right charge. Maybe I haven't charged harshly enough. Maybe I've charged too harshly, so now we've jeopardized, having an outcome where there could be some consequences for the accused. Or maybe I've just got the wrong charge and I shouldn't be charging the accused. How do we protect the community if we don't have that information to make the right decision, the just decision? So we can't hide behind, I might learn something that undermines my case and think that that's appropriate. It's not. That's what you are charged with in that position of an assistant Commonwealth attorney or the Commonwealth attorney.
And Buta, help me out here. I don't want to get too deep into the weeds and inside baseball of the prosecutor's office, but to the extent that the victim discloses something to victim witness or they disclose it to law enforcement, it's still Brady material, is it not?
It should be, but Brady is in the eye of the beholder.
Brady's in the eye of the beholder.
Many times we've gone before the judges and asked for Brady, and the Commonwealth says, we know what our burden is, and that's all we need to be told. And the judges nod their heads, repeat what that was said, and you move on, and you come back after the fact or closer to a trial date. Oh, by the way, here's what you were asking for. We now have it, and now we have to give it to you. And it's to ambush. It's lack of preparation. And I don't think anybody in the Commonwealth Attorney's Office is fully intending in their mindset to want to undermine it. But sometimes it's that focus on the conviction rather than on the justice. And it makes it hard for them to do that.
A win-at-all-cost mentality,
yes,
which is not what a prosecutor should have.
No, because you do an injustice to the community.
And in fairness on that, I think while the adversarial system is the best one out there, and many other sophisticated legal systems in the world have accusatory systems, and they apparently work for them. But the adversary system, if you want to call it a drawback, does have the component of what happens in competition and winning. And in some ways, winning becomes sufficiently exaggerated, sufficiently important, that the importance of fairness and justice get diminished. And I think that's where the Brady issue starts getting pushed aside a little bit. People start playing games, and prosecutors start worrying about their win-loss record, and it just undermines the overall sense of trust and confidence in the system as being completely just, which is where we want to be ultimately. I realize that's a high standard, but I think human nature about competition gets in the way of getting a truly fair result too often.
You're talking about that's a high standard, high expectation. We should be so aspirational, right? Because rarely do we have a goal that's so high that we meet. But if we're slightly below a high goal, it's a hell of a lot better than being above a low goal, right?
Yeah.
So that's why we do that. We hold each other to that standard because it's almost like law enforcement, right? Nobody wants a bad police officer on their police force. That is actually creates an unsafe environment for all the good officers.
Sure.
So when they start talking about, are you attacking law enforcement? No. We don't want that bad apple in our bunch. I go to court, and if I see a defense attorney or a lawyer who's not doing their job, I cringe, and I want to punch somebody in the throat to say, what are you doing? Because you're making us all look bad. and you're undermining our system. We don't want that. We want to raise the standard for everybody. So if we do that honestly, then we have more faith in the system. So when something happens, we're comfortable.
You're listening to Law and Community, a podcast from Burnett and Williams Personal Injury Lawyers. To learn more about the attorneys or the firm, find us on the web at www.burnettwilliams.com.
When we don't have faith in the system and we know bad things are happening, then we do worry. What happens when you have a truly innocent person who's going to be before the court, but because we've cut corners or not held one another, and one another's got to be defense attorneys, prosecutors, law enforcement, judges, witnesses, to that standard. When we don't hold each other to that, bad things will happen. Who wants to pick up the newspaper on a particular day and say, wow, 10 years ago, we convicted somebody, and now we found them to be completely innocent? We saw that with the Central Park Five. Why? Because it was gung-ho, and they needed to get somebody arrested. They needed to prosecute. They needed, and lost sight of what was the truth, what was inconsistent, that was evident, because they wanted to get to that end goal. There's nothing wrong with having a goal. It just has to be the right goal for the community, which is always to do the just thing.
And that's the again, human nature in some respects getting in the way. That need to know that, and I think there are a lot of people who are in jail today that DNA testing has proven shouldn't be there. That they got there because it was almost close enough. Mm-hmm. And the idea was, or the motivating factor in it all was, it made the community feel better that they had convicted somebody, so they felt safer, even though maybe it was a stretch, and falsely so. It's an odd type of human reaction that is in cold analysis is not logical, but in the heat of the moment and fear and lack of sense of safety for ourselves and our children and our families, we can find ourselves in that box to a certain degree. And I take it that your role is probably, as a Commonwealth attorney, would be at the forefront of avoiding that phenomena, if that makes sense.
It is, because think about safety. True safety is when the system works. False sense of safety is when you get the quick answer and you get placated. But then what happens when 10 years later you found you convicted the wrong person? Look what you've done to the community. One is obviously you've harmed the innocent and his family. But for 10 years, a bad person has been in our community. So think about that. That's the true cost of safety, because we didn't get the right person. So now that person is a continuing threat to our community. Whew,
and equally important, probably faith in the system.
Yes.
Well, and an increased threat in some respects, because from the perspective of the individual that didn't get caught, the mental outlook going forward may be, I can get away with things.
Sure.
Go for the next shot.
Yes.
Which I agree with you, with the safety factor.
Right, because they'll stop looking for that person.
Tell us a little bit about your thoughts about disparate treatment. You know, we read a lot in the paper about, obviously the black community having a much, much higher rate of both incarceration and overall penalties in many jurisdictions. I don't know what those statistics are, if they're kept in Loudoun County, but certainly you've been there in the trenches for a very long time and get to see how well-heeled individuals with an army of highly paid attorneys are treated versus a person who gets a random court-appointed attorney. What do you see? What's that look like to you in Loudoun County?
I wish we were able to have the data that's specific to Loudoun to be able to talk about that, but there's no requirement that that data be kept. That is one of the positions that I am going to change in that office. We are going to keep data, because then you have proof as to how you implementing certain rules. Because anecdotally, practicing for 25 years, I can give you 25,000 stories, right? Because we see it or we hear it or, we've watched it, something. But data is your best source. So when you're sitting there and you're saying, here we have marijuana cases, petty larceny cases, trespass cases, and anecdotally we see in a courtroom that people of color are being treated differently and negatively, disparately for it, it's easy to say that, but what's your proof? And you sit there and you go, well, I saw it in court. Come on, right? That's so open for interpretation. When you have data and you could show it, then it requires the person who's in office to say, you know what? Let us look at this. How are we getting here? And it's not a matter that I think that somebody is inherently prejudiced, but we have to talk about this anomaly called implicit bias. Implicit bias is real. You know what? We have people who have never had maybe a member of, the community of color that's been a member of their family, their social circles, anything else like that. So when they come to court and they see a white kid, and the white kid could be 19 years of age, so it doesn't have to be a juvenile, they look at that kid and they say, you know what, that kid's got promise. He could be going to college. He could get a job. We don't want to really screw up his trajectory in life. Although the facts may be there, convict, let's figure out what we could do to be creative to get consequences, but not break them. Change the color of that person. I don't have that same ability to look at that and say, you know what, that might be my nephew, that might be my son, that might have been me 20 years ago, because I don't have that same lens. So it's not that I'm prejudiced, I just don't have that affinity. Not having that affinity and then not having diversity within the office, diversity within our courts, nobody is impacting how we view that. So it happens every day. The clients I have, I see it. I am not exaggerating this when I say if I've got an African-American client who's coming to court, I have to work 3 times as hard to convince my prosecutor that this person is worthy of a second chance. I bring my white client in. I don't have to show the transcripts. I don't have to show that they have a good, excellent driving record. I don't have to show, because it's presumed. Right? He's a member of our community. Of course he comes from a good family. And in Loudoun County, we're very fortunate. A lot of people are actually evenly set up from a financial or successful perspective. That a lot of them have equal opportunity if we don't have that implicit bias. So we want to have the opportunity for success versus not. Having been a substitute judge, I would see cases that come before me, and I would wonder, we got possession of marijuana. Why is somebody pleading guilty and being found guilty, and somebody else is getting an amended charge that it's not drug-related, so it doesn't hurt them in college, is not requiring them to be found guilty, but other opportunities, and it really opened my eyes that there is something wrong with how we're doing things. But we need to figure out with the data how we're doing it so we can make those changes based on statistics, not just anecdotal stories. And that's the hardest part, is being able to convince people that it is your lens. Your lens affects how you come to a case. So that's what we want to be able to do, is we want to be able to have the data. We want to have the transparency within that office, as well as have some sort of, diversity so people can share those experiences with one another, because maybe I'm more mindful if one of my colleagues is African American, or one of my colleagues is, Asian, or one of my colleagues is something different than the entirety of that office. In that office, there's 17 attorneys and almost 20 staff members. You could go over there and on one hand and have 3 fingers left over. You can see what the diversity is from that. And it's just not diversity of race. It also has to be diversity of experience. You don't have many people over there who have ever been a defense attorney, or who have ever been in civil practice, or who have ever had some different law experience that can say, let me come to the table with something different. And that's all we need, is we need a mix that is reflective of our community. We don't have that.
Are we not keeping the statistics that will get us to the answer? Or does the raw data exist, we just haven't analyzed it appropriately?
Both and both.
Okay.
So we've had cases where people have tried to do a FOIA request to the sheriff's office. How are you arresting people? What are you arresting for? What's the frequency for what types of charges? And then to move that to the CA's office. How are you prosecuting? There is data that comes from the OES, Office of Executive, from the Virginia Supreme Court.
Oh, right.
Secretary.
Right.
All right. So they have data which can tell you the tail end as far as with some demographics, but the demographics also are somewhat inaccurate because they're not kept necessarily on race. Because you have white, non-white, and you may have African American, but you don't have Hispanic, right? That's a person of color. Southeast Asian, that's a person of color too. So you don't have those demographics that would be precise enough that you could draw from it. So when you look at that, you could glean some things, but it's not as accurate to come back and say, all right, let's talk about how we're doing things in this office and how can we deal with and work hand in hand with law enforcement from a community perspective. 47% of our community is non-white. 7% is African American. 16% is Southeast Asian. Right, so when you start looking at that, it's not an African American issue. It's a community issue. This is a community issue. We are Loudoun County. We can do better. We just have to have the data so that we direct ourselves where we want to go.
And solutions are so difficult to come by when you're dealing with such complex subjects. But something like keeping data or keeping statistics, that's a concrete, very attainable step.
It is. And the coolest thing is, because I've been looking into grants on the federal level, there's some good money out there. They'll come and help you. Mm-hmm. So you don't even have to come out of pocket. It's not like, here we go, got to take $1 million and do this. No, they'll come out and help you. They'll help you. They'll educate, and they'll put in programs to be able to amend that.
Well, and Buta, because our time is limited, I want to make sure I hear some of your good thoughts on a couple of other subject areas. And one is, of course, as you know, and maybe this isn't such a big deal in Loudoun County, but I'm sure you'll have an answer for this, and that is, with Loudoun County having the highest median family income in the country for the last couple of years, and by a country mile, for what it's worth, I think the national median family income is about $60,000, and we're at about $135,000, so 200+%. That sort of raises the issue of this that we've been hearing a lot and reading about of cash bail. Some might think that Loudoun County, they're also stinking rich, that anybody that's arrested can just stroke a check for their bail. I tend to think that's probably not so. But you're in the trenches. Tell me and John and our listeners what you think about this cash bail issue and how it applies to Loudoun County, if at all.
Let's start with first what the law is. The law in the books is very appropriate. If you're not a risk of flight and an unreasonable risk to the community or yourself, then you should be released.
So flight or committing another crime.
Right, some sort of danger to the community, right? Okay. So it could be the level of the offense, the nature of the violence, things of that nature. So if you have an offense that's a low-level offense or a crime not of violence, then it is actually imputed within the code section that you should get out on, you should be at liberty pending your trial.
On personal recognizance, is that what it's called?
Personal recognizance, then if there's some problems with that, then it could be a secured bond. But where we see the courts have misused this in the past is the fact that there is not that sense of appreciation for what a dollar amount is. So as you said, maybe everybody at this table, if they go to court and they have a $5,000 cash or corporate surety bond, it may not be that big a deal because it's 10%. What's $500? But when you look at the person who is being charged, $500 might be my rent, part of my mortgage. It could be food on the table for my kid. It could be my car note. I can't afford to come out of pocket and pay $500. So I have to stay in jail. When we start talking about what the true cost of the community is this, what person can maintain their job and somebody hold it for you if you've been in jail for a week, or like sometimes these cases take 45 to 60 days to go from charge to completion as a misdemeanor. Who's going to save your job for 60 days? Not a whole heck of a lot. So now what we've done is we've created an unsafe environment in our community because there's instability in the home. People are relying on a second or primary wage earner. Kids need their parents to have the jobs. The employer needs the daggone employee to come to work. So we're creating this instability that costs us more than the $500. Also, what ends up happening, and I saw it as a judge and I saw it as a defense attorney, you have somebody who's charged with something who has the choice to pay the bond, or maybe I plead guilty to the charge, which I didn't do, or I did something different, or I did something less, but I can't wait for my day in court. I'll plead guilty because you told me this. I get out of court tomorrow. I'm sorry, out of jail tomorrow. If I get out of jail tomorrow, how do I not weigh that in my decision making? It's not did I do it or did I not do it. It's can I go back home to my home?
And a variation on that to me is very troublesome is thinking about an individual who can't put up a bond, or maybe the magistrate won't give them a bond amount or whatever, holds on to them, and there they sit until they can get in front of a judge. They're picked up on a Friday night. They can't get in front of a judge until Monday. The judge lets them go on their personal recognizance. Now they've spent 2 days in jail. It comes to trial, and prosecutor says, time served. And you have to ask the question, gee, were they going to get 2 days if they'd posted the bond? Would they have, on a first offense, had to spend any time in jail? So I worry about that. And again, there's something the statistics could tell us something about, perhaps. It is.
And it's a legitimate concern because of a number of reasons. One is we have to realize, and I'll tell you this, as an attorney who goes to the jails to visit my clients, I've always been fortunate. Last 25 years, every time I knock on the door, they let me out. And I have that expectation when I go in that I'm going to get out when I tell them I'm ready to come out. It's a very traumatizing experience. I have clients who get arrested, even if it's just overnight and they get out the next day. they, to the core, are traumatized because they put in handcuffs. They've been shamed. You get strip searched when you go into jail. When have you ever let anybody touch you like that? That's not, hopefully in a romantic or medical, aspect. And then you have to be in there, and then your fear is, oh my gosh, who are these people around me? That's a lot of trauma did we needlessly cause. Because what we want to do is when we punish crime, we want it to be appropriate to what was the crime that was convicted. If we're over punishing somebody, so we're over traumatizing them, that's not really justice. That isn't. And because we have the power, we have to be mindful of how we use that power. It can't be just because I can bully you into doing something because it checks a box and I'm done with your case. What is the impact that it's going to have to that community member when they're out?
And also think about the most efficient use of our resources as well.
It costs $66,000 a year to house somebody in our Loudoun County Adult Detention Center. So when we start talking about this, I'm going to give you two stories if you have time for it. We had a kid, first-time offender, possession of marijuana, right? And we all know what the trend is going to be nationwide. It may be legalized in Virginia within the next 1 or 2 years. But in a lot of states, it is. D.C., you can smoke, come back here, and, not have violated while smoking, but maybe violated by having consumed it in Virginia. But the point becomes we had a kid who had a deferred finding and he blew it. So to his detriment, he didn't follow the rules. He goes to circuit court. The judge gave him 30 days to serve on a first offense, possession of marijuana. So your face is like, what? But then I look at it, forget about what they did to him, right? A young adult, an emerging adult, somebody who's hopefully getting more mature as the days pass. But you just took $5,000 from my tax base to house somebody that was not a safety issue to my community. Then what could have I used for that $5,000 with? More police, counselors, drugs, school teachers, something, because I'm a businesswoman. I want a return on my investment. Okay, I'm not interested in shelling out money that I never see the positive of it again. Because guess what? We can't be affluent and the richest county, in America by wasting money. There was a guy who stole tires from 6 cars in Ashburn, and they stacked the charges. They hit him with 18 felonies. Grand larceny with the intent to sell because he was feeding his addiction, because that's what he would do. Who needs 24 tires? Nobody. But he would sell them to feed his addiction, which was opiates. And then they also hit him with destruction of property. Goes in front of a jury because the facts are there. Jury finds him guilty of all 18. Jury makes a recommendation. It goes in front of the judge. The judge gives him 17 years to serve.
Wow.
Again, if you take him down, state time is $25,000 a year. That's $475,000 that you just took from our tax base to house somebody who's got a drug addiction. How about we be more mindful as to what that money costs to us? Because for me to pay $475,000 is a lot of money.
And how much threat this guy is, and what you might do for him and his family and the community by spending maybe $100,000 on counseling and testing. And
it's not even that high. You could do a program for $25,000. The best program could be $50,000, right? But then what you do is you return to the community, and he needs to get a job. He needs to pay taxes. He needs to support his family. So those are things that help the community.
Becomes a positive contributor versus a draw on
That's
on
exactly,
our taxes.
because we'll never see that $475,000. When he gets out in 17 years, guess what? He's still going to be on our cost as far as maintaining something. And
we don't know statistically, at least, what the potential is for him going back in again.
Well, there's a high recidivism rate when it comes to drug use and drug abuse, and also mental health. So that is a high recidivism rate. If we don't address the problem, all we've done is created that turnstile, right? In and out, in and out, in and out. And again, it's a negative outlay of our resources, human as well as financial, because I don't want to do away with the human factor. It's a human loss, because these people are being exacted from our community, which they may not otherwise have to.
And on another day, we'll talk, because you've got so many good things to talk about, the subject of, unfortunately, jails too often becoming a substitute for a mental health facility. And that is really too bad, because it's both expensive and not particularly helpful.
Correct.
It doesn't solve the problem.
No, and as was said earlier, we have to be more solution-based. Because it's real easy to check the box and incarcerate somebody. But that's not a solution. We're not going to incarcerate ourselves out of those problems.
And tell me, I've heard you talk a little bit about truth in sentencing. Tell me your thoughts about that.
My hope for this office is going to be the following. In 2 circumstances, we're going to be much more directive with a jury. We're going to talk to them about how much it costs to incarcerate somebody. So if they do want to give somebody 17 years, then they're going to know how much it costs. But you can't do it on the blind. And the other thing that we're going to talk about is mandatory sentencing. Because I've had many cases that I've either watched or had myself where jury gets, because it's bifurcated, which means it's separated. You get the guilt and innocence factor, and then if they're found guilty, you go to sentencing. Where juries are then learning that there's mandatory minimums. And when they get those, I've had juries in the back yelling, screaming, and crying. And I've talked to prosecutors and said, did you talk to that jury? And they're like, no. We didn't talk to the jury because they were upset at us because they felt that we duped them. We tricked them. Because we didn't tell them what the sentencing has to be in certain charges.
Oh, at the time of guilt or innocence,
yes.
the jury didn't know.
They didn't know.
They were going to, if they found them guilty, they would be forced to impose a sentence of X.
Correct. So this is why I'm saying truth of sentence, because the jury has to know what are they being charged with. What are they, when you're telling me I've got this responsibility, you're trusting me to make the right decision, then give me the information. Give me the information as to what the true cost of the community is going to be for us to make those decisions. And then they can make whatever decision you want, but we want them to have a fully informed decision.
So how do you address that?
Judges will allow you to do that if that's not objected to this prosecutor. That's the power of the prosecutor. The power of the prosecutor is greater than any judge. It's greater than anyone else involved in the criminal justice system. And that's where you have to say this. As a prosecutor, you have to be a member of the community. You have to know what, at the end of the day, what you're trying to do is to say to the community, I'm trusting you to make that decision, so I have to trust you with the facts. They can take those facts and make that decision. But if you don't give it to them, then you've kind of lied to them by omission. That's not a good way to put a community in, because guess what they say is, the system sucks. The system is not fair.
It undermines trust in the system.
It does. Because then they sit there and go, oh my God, whatever happens if me or a member of my household or a member of my community, somebody I know about, what happens if they get accused? I don't trust the system to do the right thing. Right. So at the end of the day, we want to have trust in the system.
That's terrific. Buta, thank you so much. Thank you so much. And all I want to know is whether you'll come back and talk another time or two about some of these various items in depth, because you've clearly given them a lot of thought.
I would love to.
Thank you for coming.
It's been a true pleasure. Thank you, Buta.
Thank you.
Thank you for listening to Law and Community, a podcast from Burnett and Williams. If you have any questions or wish to learn more, please leave us a message at our website, www.burnettwilliams.com. Also, please don't forget to subscribe to the show on whatever platform you're listening to. Don't forget to follow our Facebook page at www.facebook.com/BurnettWilliams and give us a call at 703-777-1650 for any questions you have. Hope you enjoyed the episode. Until next time, take care.